Hello everyone, you join us again today for another family vlog from Bennett Griffin. So myself, Jackie Mensah, and my colleague.
Hello, I'm Sarah Pennicott.
Hello. So as part of our series of really sharing and educating about family issues, we've got a very special guest today. We've got counsel barrister Scott Sharp joining us from Westgate Chambers.
Hello, thank you for having me.
Scott.
Thank you for coming.
Thank you very much. And today we're talking about something which is really important for a lot of people when they're going through the whole experience or process of dealing with lawyers and having to sort out legal issues, and that's really alternatives to court. And there's a whole plethora of areas that we could cover within this in terms of the options available to clients. And I think, Scott, you've got some experience of this, of the range of options available.
Yes, yeah. So just a little bit background to help. I had quite a civil practice before I came to the bar as well. So
Right.
to dispute resolution were always options that were kept on the field there. So coming into family, and obviously the very similar options being available, and skill set as well.
Yes.
And sort of assist with that. But of course, when talking about the family options, typically what come to mind are mediation, arbitration, and then of course there's slightly more newer things which I'm aware of as well, the collaborative lawyers approach, and because I do finance as well, I'd probably be remiss if I didn't mention private FDRs.
Of course.
But those are the ones sort of I've got quite a bit of experience with.
Yes, yeah. And have you seen in recent years an increase in the use of alternative dispute methods of resolving disputes? Because obviously there is a big push towards it. Often when we first see clients, they don't necessarily know that there is any option other than agreeing at the outset, or then going to court. So we obviously advise them. Have you seen an uptick in it?
I think it's difficult on my end because, of course, we see them once they get to the litigation stage. But I would certainly say I've seen the encouragement for the uptake of it beforehand. And certainly judges at every stage, bar a final hearing, whatever family hearing I'm doing, are constantly reminding the parties that just because they're in litigation does not mean they can't discuss settling and other ways of getting things resolved. That has been a massive uptake. And I mean, again, it's a massive trend, which personally I would say is encourageable as well, because nobody wants to be in court. I'm probably talking myself out of a job here, but it is easier than the litigation process.
Yes, and quicker.
Yes, yeah, certainly much quicker. And again, I think this is why we've seen that trend of the courts encouraging the parties to really think about their positions and think about whether or not they can discuss and or agree outside of the court arena, because the courts are just backlogged. That's the honest truth to it. And depending on the type of hearing you're doing, I mean, every case I go to now, I'm saying to my clients, the next hearing is going to be months away.
Yeah.
It's not a quick turnaround.
Yes, yeah. And with the courts being able to adjourn matters so that parties can do things such as mediation, have you seen people using that time between the hearings to engage with alternative methods of resolving the dispute?
Unfortunately, I can't say I have, mainly because I think with such delays being between the hearings now anyway, it's not a matter of adjourning so they can mediate, because otherwise, if mediation fails, they're back to a similar hearing that they've just been through, and then directions to the next contested hearing, which delays the process further. But as I say, I think this is where the judges are going very clearly, fine, well, let's diary on to the next contested hearing, but you are fully encouraged outside of this to talk. And as you know, we've got the guidance now in family courts of making every hearing count, really narrowing the issues. And of course, our approach as barristers, what we're ordered to do in turning up typically an hour before most hearings anyway, position statements, real discussions to narrow issues, I think is the way the courts are doing it. I'm not saying, of course, that it wouldn't be fantastic if the courts could adjourn to allow mediation to happen, but I think the realities is there's such timescale between hearings at the minute anyway. If the parties are minded to do that, they've got the time regardless.
Yes, yeah. And I suppose in terms of a lot of our clients are obviously concerned about costs, which is completely understandable. But with those delays that are happening anyway because of the court system, it's all the more important that they do try to settle in between, isn't it? Because there will be so much updating information that would be otherwise required. That delay is increasing people's costs because their financial situation is changing between the first appointment and the next hearing.
Yeah, definitely. And I think the stark reality is litigation costs a lot of money because you're paying a lot of professionals to do a lot of work, and alternative dispute resolution and the ways to do that are quicker, easier, and parties get to remain in control effectively. They're not paying a solicitor in the nicest way to spend months preparing documents for the next hearing. They can get documents ready themselves, and typically, you know, mediation, you don't have lawyers involved. It's either party turning up with a mediator, and it's the only one person you're paying for their time for that day. And again, that's typically a lot cheaper than even instructing a lawyer nowadays to look at documents.
Yes, yeah. But I suppose the other message to send to the lay client is that although it's just them and the mediator, they then can get advice in relation to the issues that are discussed. So they can come see us, or they can come see you, or if it's complicated issues, we might ask you to get involved. So they can still have the benefit of the legal advice, even though they're engaging with one of the alternative methods.
Yes, certainly. And you know, I've simplified it to say if you're solely using mediation, of course.
Yes.
The benefit being that this is alternatives. You can overlap, you can get some advice from a solicitor, set up your own case and then go to mediation. You know, you can, I think principally it's a matter of how much funding you want to put into it to avoid litigation. And that is going to be different for every single client. Every single client's financial position is going to be different. What I would say though is part and parcel of that comes with approaching alternative resolutions with the right mindset.
Yes.
And I think the mindset in which you approach alternative dispute resolution is exactly that. You're coming for a resolution. You're not coming to fight a case, because that's what litigation is, and that's what I see a lot of, unfortunately. And you know, try to encourage at every appropriate hearing with my clients of, I understand you want to make that point and you want to make that argument, but if you do that, it's going to cost time, it's going to cost money, and where is it going to get you eventually? It's a very minor point. Let's move forward rather than look back at the past. In appropriate circumstances, of course.
Yes, of course, of course. It's I think, as you said earlier, Scott, when you were jokingly saying this would do me out of a job, and of course, what we're talking about is using the right expert at the right time.
Yeah.
And that will make it cost effective for the clients as well. So, as you were saying, Sarah, as far as mediation is concerned, I mean, we work concurrently with the clients, alongside in the background. They can dip in and out of mediation. And the same applies to collaborative as well. I'm a collaboratively trained lawyer, and it can work for a lot of people. It depends on their needs and how they want to operate, really. But it does give them that level of control because they are setting the agenda, and that's what it's about. But coming back to what you said, Scott, that obviously you need people to engage and be receptive to it. And that's the whole thing about the alternative process, is that you're saying, look, this is going to benefit you and your family, and predominantly, especially if you've got children's needs. But you need to actually sign up to this on a voluntary basis and want to do it.
Yeah, of course. And I mean, the courts, as we go back to their encouragement to all of this, with most family cases, of course, most people are now required to go through the MIAM requirement before coming to litigation anyway. And, you know, that being the initial mediation information assessment meeting to kick off effectively whether or not mediation will be appropriate. There are certain circumstances that's not appropriate. You know, domestic violence, we all know as professionals, is typically one in a setting where that won't help. But I think what isn't known is there are ways to appropriately manage that as well, such as shuttle mediation. You know, you don't have to be in the same room as the person you're trying to speak with. The mediator can go back and forth and provides that layer of protection. But it does require everybody to come with the right mindset. And that's probably one of the negatives, I would say, about mediation is if you get one party very much in the position, typically the if I may say, the weaker financial position as well, where they want a quick resolution, they're willing to put bygones to one side, and it's the other party who says no. That's where mediation can't really get you much further, because of course a mediator can't force a resolution. Arbitration, of course, is an alternative option that the parties have to agree, where there can be a resolution. But that is probably one of the negatives of, you don't have a individual telling you that is the right outcome. You've got the parties who have to come to it 9 times out of 10.
Yes. Yeah. So do you think, other than domestic violence situations, generally, do you think mediation works for most people? Or is there a type of person you think, oh, this is not?
Again, it's really difficult. I think the situations themselves are unique in respect to domestic violence. As I say, it's one's outlook on what they've been through. If we're talking generically about people, I think alternative dispute resolution can work for anybody if they come at it with the right approach.
Yes.
And you know, there are options out there. Just because one type of alternative dispute resolution, you know, we've spoken about mediation quite a lot, doesn't look appealing or might not work, doesn't mean the other options that we've sort of alluded to couldn't work for you. It's, you know, choosing and maybe doing a bit more research into what's going to work. And what I would say is, and I say this with all my clients as well at hearings where we're trying to get resolutions, is, what about the other person? What are they potentially thinking? You know, they equally want this resolved. What might be a good, suitable way of alternative dispute resolution for them?
So you've touched sort of on arbitration. Have you seen an increase in the use of arbitration? Because we're obviously involved initially with the mediation, and arbitration doesn't seem to have taken off as much as mediation, but has benefits in the same way as mediation. But have you seen an increase in the use?
Arbitration itself, no, but that's why I akin this to the private FDRs within the finance, because again, that is being spoken about and being, I think the issue is a lot of this is hidden in the background for a lot of years, and it's now being pushed. But the private FDR hearings are no different effectively to a court-ordered and judge-sitting FDR, save for the fact the parties are paying for the expense to get it done a lot quicker. An arbitrator, well, also, apologies, I should correct myself, obviously an FDR, that person holding that can't still force a resolution upon the parties. They can give the indication. An arbitrator is, if anything, the next step to that, where actually if the parties are prepared for somebody to make a decision and wants it to happen, quite frankly, far quicker than the courts are going to make it happen, that's what the arbitrator is there for. But I think, unfortunately, it's an underutilized resource.
Yes, yeah. And you touched on, obviously, with private FDRs, the clients generally share the cost of that, but they will have to meet the cost of that. But as we talked about earlier, the delay within the court system can lead to increased costs, which quite quickly could outweigh the cost of that private FDR. And so it's sometimes, I think, clients can be quite put off of private FDRs because they're having to find those funds. But it's almost a false economy, isn't it? Because the overall cost is probably going to be lower.
Yes, certainly. And again, as I say, I run through these exercises with my clients at the appropriate hearings, where the idea is we are seeking to try to get a settlement and resolution. It's always going to be an economic balance as much as anything else. If you're particularly finance, for example, if you're not that far apart from the other side, in the nicest way, emotions run high. We're talking about families, of course we are. Us as lawyers, we're one step removed from the circumstances. But I encourage everybody to always look about the longer term economics. You know, although you might be arguing over £10,000 now, and that sounds a lot, in terms of legal fees, that the default position is you don't get to recover them. You could spend that plus some just to take you to a final hearing and win your point. the question is, and as I say, it goes back to that mentality earlier, is that point really worth winning when financially it may be not beneficial? And you are right. I think it's the same with private FDRs. People see the upfront cost, but they don't balance that against the longer term court litigation costs.
Yes, yeah. If parties opt for a private FDR, so they've issued an application for financial relief, but then they decide they want a private FDR, does that mean that the FDR listed by the court is vacated and proceeds straight to a final hearing if they can't reach an agreement at the private FDR?
In my experience, yes. My issue is I could very much be wrong on that in the nicest way, but I do understand effectively if a private FDR is agreed and directed, the courts recognise that as the FDR step. I mean, when we're talking about financial remedies anyway, there's typically the 3 hearings. There's the first appointment, the FDR, and then a final hearing. Of course, there's always been arguments that the FDR, whilst encouraged by the court nowadays and is a typical step, if it's unrealistic, the parties aren't going to settle, then what's the point in having that FDR? Because it's wasting the court's time and wasted costs. So having a private FDR, I would say, if that had failed, then yes, it's by all means appropriate to skip that step in the court and go straight to a final hearing. Yes,
yeah. And do you find many matters do skip straight to a final hearing, though? You said if there's no realistic prospect of settling, it can skip from the first appointment to the final hearing. I don't think I've had any experience of that actually happening in practice, because it's that usual process that the courts just apply the timetable.
So I've only had one case where I had it. And again, I say this is the exception to the rule.
Yes.
That's where we didn't have the engagement of the respondent at the first appointment. So of course, despite there being the possibility they might engage further down the line and come on board, the reality was they hadn't engaged pre-proceedings, they hadn't engaged at this appointment. Even if they did engage then, were they realistically going to engage for an FDR, and would it be effective? Or was it just going to be wasted costs? Now, I made the argument for my client, well, it's going to be wasted costs. It was a fairly straightforward matter. Long and short of it is it's an agreement, or a judge needs to make the decision. So we went straight to final hearing. And under those circumstances, I think it's a careful consideration of when you're at a first appointment, again, how far apart are the parties? Is there a reality that with further guidance from the court will say yes? You know, their default is actually yes. Coming back to court narrows minds, giving an indication will help. But if it's so glaringly obvious, that's obviously then for the legal team to make the argument that an FDR isn't going to help, go straight to a final hearing. But they are very rare, as I say, you know, that's not the norm.
Is it also the case, Scott, that with the alternatives, dipping out of the litigation conveyor belt almost might diffuse the situation? Because I've had cases in which issues about maybe conduct or behaviour or allegations of, you know, fairly low level have arisen, which have then become a blockage in terms of negotiations about the finances or children. But sometimes then if they come away from that and go into something else, for instance, mediation, it can actually diffuse it. And I'm also thinking about the advantages being that it's then a private forum. So there's the privacy element as well, rather than all of these issues being dealt with in court, where there is the risk that things could be reported on. That's the reality now, isn't it, within the court process?
Yes, of course, you know, and I think going back to what you were saying about diffusing, that's the very essence of these alternative remedies. Is, for me, certainly, as I say, day to day, I'm in court. I see clients every single day. And the court environment is a court environment. It's very serious, you know, despite the use of some remote hearings. And as I say, there's a step away from that now. Everybody feels in a court environment, it's them against us. Be it TV to blame for that, because the TV shows show us constantly at each other's throats. The realities are the courts don't want parties to be going at one another. And actually, if you've got a bit more control over what's being said and done, it is likely to defuse. You look at And again, I try to encourage some clients to do this rather than looking at what the other party has done in a court arena and going, they're only doing this to make themselves look better in front of the judge. You can take a step back and go, well, hang on a minute. The perception to that, if you were on the other side, would you not say the same thing? You know, it's trying to get that balance. And again, probably negatives to my job. We as lawyers act on our clients' instructions. If they tell us to fight for them, we fight for them. And as you say, one minor issue that might appear minor in the first instance, if our clients tell us, well, actually, that's a real issue for them, we will find those arguments for them. And again, in the nicest way, you know, we all are there to do our jobs. If we are there making mountains out of molehills because our clients tell us to, that breeds a more hostile environment. You know, these alternative disputes, I think the very fact that the starting point is we both kind of want to resolve this without going down the hostility that everybody believes the litigation process is, and it generally is a starting point where everybody's more relaxed, be it with solicitors still involved, with a lawyer still involved, with an arbitrator or mediator. It's still a much calmer environment all round.
Yes, definitely. And it's also part of our role to give our clients options, isn't it? Yeah. Really, that's how we best serve them at the end of the day.
Yeah, certainly. And that's obviously what we are there to do, to give them honest and realistic advice as well. And to give them all of those options. And as I say, alternative dispute resolutions, there's been murmurs, but I don't think it's necessarily pushed quite as much as it could be.
No, no. And I think the upshot really is that there's a place for litigation where perhaps there's an imbalance of power, or there's somebody hiding assets, or those kind of situations. But it's that, like you say, giving them options, and some of the options are appropriate for some people, some are appropriate for others. It's not one size fits all, and it's finding what's right for our clients.
Yes, yeah, exactly. And that's why I say there are lots of options out there. It's a lot of people know of mediation because that's the one that's pushed, but there are varying options out there which are very good. And under the right circumstances, that's of course where you guys can offer that advice to begin with. What might be the best avenue for this? Yes,
yeah. Well, we've obviously talked a lot about the advantages of alternative dispute resolution methods. Do you think there's any disadvantages? Obviously, in some cases, it won't be appropriate. But for those that are, do you think there's any disadvantage to trying those methods?
As I say, the disadvantages that immediately come to mind are, if it fails, you're still in litigation, or you're still going to have to start litigation. So there's an additional cost that you've incurred. But what I would say to anybody who might take that mindset of, well, I don't think it's going to work anyway, flip that attitude on its head of, well, if it does work, you have saved yourself thousands of pounds of litigation.
Absolutely, yeah.
It doesn't work, as I say, you know, potentially on the financial remedy side of things, you come to court at that first appointment and you go, we've just done 6 months of mediation. This is the real sticking point that we've got to. We don't really need an FDR. You know, as I say, that's potentially an argument to say, let's skip that stage because we've already done a lot of that. We just need a judge to make a decision now.
Yeah, yeah. And we see that even if it's not successful in that it hasn't come out, that the parties haven't been able to come out with an overall agreement, they may have been able to agree some issues. And so therefore, by narrowing those issues, it can speed up the court process and it can reduce their costs because they have removed those things that, like you say, aren't worth arguing over. And they've got down to the nitty-gritty of what really matters and what is really in dispute.
Yeah, exactly. And again, whilst there are disadvantages, it's that balance exercise, isn't it? It's even if I've done this, it's not a total waste. It's having the right mindset moving forward of, well, you know what? I also know what they're now going to say in terms of that. So I can come prepared and I can have the right focused discussions with my lawyer, with my barrister when I get to court, rather than reciting 10 years history.
Yeah, and it could also be absolutely fundamental for parents, couldn't it? Because if they've had issues between them, moving forwards, if they've been able to engage in an alternative process and they're actually talking to each other with the assistance of an expert, then hopefully they will continue to talk and at least have a civil level of communication for the benefit of the children. So long after we as the lawyers have disappeared, they've still got that, hopefully.
Yes, certainly. And I mean, talking about children's cases as well, of course, one of the key things the courts are dealing with a lot at the minute is the use of technology. And of course, a lot of the time parents say they're not talking to me nicely, they're talking to me poorly. I probably would be remiss if I didn't say that at every first appointment, or sorry, first hearing that I'm dealing with in the children's cases, there is always the question of, can these parents communicate using a specialized communication app? You know, there are free versions out there, there are paid versions out there, exactly the same as your WhatsApp, your email, but they help regulate language. You type out a message and you still get to type it out, but it will pop up and you go, probably not the best to send that, and give you a chance to think about it. And you know, other apps will have joint diaries in there, so rather than going back and forth about when they're going to make child arrangement contacts, it's already in there, so both can log on and see. And again, whilst that's in the litigation process, I do see that potentially as another form of alternative resolution, because it's starting that talk. And there is nothing, as I say, that stops parents agreeing prior to issuing proceedings to start using one of these apps. So again, it should always be in there of, although there might be communication issues, how do we get around this? How, without maybe getting lawyers involved, is there a way we can talk civilly and start that? And I have to say, a lot of my cases I see where we start with a parental app in the beginning, by the time we reach a final hearing or even a month later, the parents have moved away from that because the language in itself has just improved over X amount of months.
Yes. Do you think, just sort of as a rounding up, would you have any tips for anyone who's wondering, how do they start to choose a mediator or a collaborative lawyer or an arbitrator? Anything that might help people starting on that process?
Again, I think it is to be honest with yourself in the nicest way, getting to that headspace that we've spoken about already and going, what is the real issue, or what are the real issues? And then when you go out looking for an arbitrator, a mediator, have a look at their CVs. You know, are they an arbitrator, and we're talking about children's contact, or particularly, you know, if there's specialist requirements of the children, somebody who might have a background to understanding medical needs a bit more, of maybe being with a specialized CAFCAS unit, for example. That's going to suit my case better. Let me propose that and let me justify why I'm proposing that to the other side. I think that's always the best starting point. And again, you know, the arbitrators are fantastically trained. Of course, collaborative lawyers are fantastically trained. They're all there to a set standard. It's just, I'd never necessarily say to anybody, if you're wanting to propose alternative dispute resolution to the other side, to just provide one person either, to provide them with 3, maybe 4, and say, look, I've gone away, I think this could work for us, I think these people suit our needs. If you're up for it, have a choice. You know, you give a balance of power, rather than going, I've chosen this person and this is the only person I'm prepared to use.
That's brilliant. That's brilliant. I mean, to conclude, there's nothing to be lost in attempting these different routes, is there? Because ultimately they all lead to a legally binding outcome that can be enforced and is going to give everyone certainty. That's what it's about ultimately, isn't it?
Yeah, and again, as we spoke about, that's the real positive. If it works, you avoid the court and you avoid the time and you avoid the disruption and hassle and quite frankly the anxiety a lot of people suffer into a courtroom environment. You can do it in an office building, you can do it in a more relaxed environment that suits you. But even if it doesn't work, it has worked to a level that when you turn around to your lawyers later on and go, well, we've given this a try, they're going to say to you, fantastic, because it now means we can do X, Y, Z with your case, as opposed to necessarily having to do the normal steps.
Yeah. And I think I always say to clients that agreeing matters, whether it's through mediation or negotiations, gives you that flexibility to make an arrangement that's really going to suit you. Whereas if a judge imposes the arrangement, it might not really be what either of you want, but it's going to be what the judge decides is best, and you might both come away feeling pretty annoyed that actually you could have agreed a better arrangement between the two of you.
It's funny you say that, because strangely enough, that is an exact conversation I have with a lot of my clients as well. Is, you know, you are here, I will battle your corner for you however you tell me to do that, but reaching an agreement is at least an agreement you control, as opposed to a judge and or otherwise imposing it on you, and quite frankly neither of you being happy with it, and you both walking away grumpy with then, oh well, he or she forced me down this route, neither of us got what we want, now I'm really annoyed. It's again sort of almost mitigating emotions as best as possible as well.
Yeah, that's fantastic, Scott. That really is. Thank you for your tips and insights and your expertise, and for sharing the same with us. Hopefully that's given everyone something to think about. And thank you today, Scott.
Yes,
that's right. As I say, thank you for having me, and hopefully it helps.
Yes, it has, really. Thank you so much. And hopefully everyone will join us again very soon. Thank you. Bye.
Thank you.